So right now, Steve is going to talk about America's Rifle, the case for the AR-15, brand new book coming out. I can't find a link to purchase it yet, but maybe Steve has one. Thank you.
Thank you, Julianne. It's such a pleasure to be here. Within a few weeks, we should have the new book out. It's called America's Rifle, the case for the AR-15. It goes through the entire history of the right to keep and bear arms, and it does say arms. We're not talking about toys. The anti-gun people like to try to say guns are dangerous, we should ban them, but oh, okay. All right. A little closer. I mean, it says arms. Arms are deadly weapons. They're not toys. And so if we go back in history, how did we get this right? And what kinds of implements were the people at large keeping and bearing? If we want to go back to the medieval days of England, you have the duty to bear arms, and that came into being particularly when the English longbow was designed, and that was a very deadly weapon. It would fire faster than other bows. There's been studies that show the effect of the arrows when they hit the person, the opponent, the enemy. There's burial sites where they've found these ruins and these skeletons, and they were every bit as deadly as modern guns. Speaking of deadly, recently the House of Representatives passed a so-called assault weapon ban, and one of the witnesses in a committee hearing, a former Marine supposedly, a woman said that if a cartridge like the 5.56 cartridge that fires from an M16 or an AR-15, wherever it hits you, it obliterates that part of your body. And then you have Joe Biden saying that it fires 5 times faster than any other cartridge. If you fire it from an assault weapon, if you fire it from a single shot, of course, it's going to be only 1/5 as fast. So we all know there's a lot of silliness involved with this. But getting back to the English bow, you had the requirement that the people at large exercise with the bow, they keep the bow. And so you can see the origins of not just a duty, but an entitlement or a right. If it's your bow, it's your weapon. And so that's why we have, like in 1824, Thomas Jefferson saying that most of the state constitutions recognize the right to bear arms as both a right and a duty. So I don't want to frighten anybody in the room with the language I'm going to use next, but most of the bans on so-called assault weapons include the feature of the conspicuously protruding pistol grip. It is so frightening, and it's got variations in terms of further meanings to it. For example, in California, there's a DOJ regulation that says a conspicuously protruding pistol grip is one where your thumb wraps around the grip. And so now we have designed what is called the fin grip. So to be California compliant, a manufacturer could sell in California a grip where your thumb has to go up and you cannot put your thumb around the grip. It's like you're hitchhiking, and it's a less stable grip. You cannot reach the safety selector from that position. And so we have that ridiculous argument that this is consistent with the Second Amendment. Like for the firearm, that the Second Amendment gives you the right to keep and bear, you have to have your thumb in the up position. And then if you look at Connecticut's definition, which Delaware just adopted, it says that you have one trigger finger, and if the other three fingers are below the trigger finger when the gun is firing, that feature makes it an assault weapon. So we argued in the challenge to Connecticut's law that when you're in a duck blind and you have your shotgun and you're pointing it up, those three fingers are below the trigger finger. That's an assault weapon. And if you have an AR-15 and you happen to be shooting down like at a deer, you're up in a stand, those fingers are not below the trigger finger. So, the district judge said, well, I guess they could have written it better, but that when they say when firing, it means the normal time or the normal way of firing, which there is no necessary normal way. So are you telling me that a rifle loses Second Amendment protection if you have three fingers that are below the trigger finger when firing? I mean, what a ridiculous argument. And then we get back to what's the design of the pistol grip? When Heller came down from the Supreme Court, the District of Columbia enacted a so-called assault weapon ban. And it had both the list of the guns, the make and model, and then it had the generic definitions, including the pistol grip. And Heller had adopted the common use test. You've already heard about that. You've known about that test a long time since it came down. The kinds of firearms that are in common use by law-abiding people for lawful purposes are protected by the Second Amendment. And so that was a no-brainer. We filed a case that came to be known as Heller 2. And we showed overwhelmingly that these rifles that are banned are in common use for lawful purposes. And so we had evidence about the design of the pistol grip. We had expert affidavits. Harold Johnson, who authored the Small Arms Identification books for the Defense Intelligence Agency years ago. We had former members of the armed forces about the purpose of the grip. And it's so you can hold the rifle in a steady way with the stock against your shoulder, and you can fire with accuracy. The District of Columbia didn't submit any evidence, but they had their legislative record where a member of the Brady organization testified in a committee hearing that the purpose of the pistol grip is to spray fire from the hip to kill as many people as quickly as possible. And of course, there's no evidence for that, and you'd be a dummy to do that. You're going to miss most of your shots. But that was good enough for the Court of Appeals. So the D.C. Circuit said, yeah, we agree these guns are in common use. We can't deny that. We conservatively estimated several million. That's grown greatly now by more buyers and also more information where we can get better estimates, like the Bill English study that was mentioned by the previous speaker. So, yeah, they're in common use, but we got you. We're going to apply intermediate scrutiny. And we're going to take snippets from the legislative record like, oh, the pistol grip, that's for spray firing from the hip. I mean, the very idea, this was a summary judgment motion, the very idea that one side presents credible evidence and the other side presents no evidence, and you rule for the side that presents no evidence is just so contrary to the normal rules. And here we have a constitutional right at issue. And so the court upheld DC's so-called assault weapon ban and didn't bother to mention why the other features could make the rifle bannable, why it loses Second Amendment protection. And then it becomes a leapfrog game. You have the next court to consider a so-called assault weapon ban. They cite this Heller 2 case. And so now there's two precedents. And then the third Court of Appeals cites those two precedents. And then the fourth one, now he's got three precedents to cite. And so you have these courts, it's like spreading a rumor, one person says it, somebody else repeats it, and it goes on and on. And that's, we end up with all these precedents. And I'm hoping that, and you've heard discussion already about the effect of Bruen, that hopefully will put a stop to this, because the Heller 2 case was the first court of appeals to say we have to go to step 2. And like Justice Thomas said in Bruen, that's one step too many. We look at text. If it's a bearable arm, which undoubtedly an AR-15 is, then the burden shifts to the government to show that it's the kind of historical restriction that's justified in the relevant period of history, which is 1791 or shortly thereafter. And this they cannot do. And that's why the Bruen case granted some cert petitions and vacated the judgments and remanded them. And one of them was the Maryland assault weapon ban. And so that case was sent back to the U.S. Court of Appeals for the Fourth Circuit for reconsideration in light of Bruen. And so the Fourth Circuit, there was a previous Maryland case where they upheld the ban. And some of you might have heard about this, that the court said that there's no difference between semi-auto and full auto. An M16 there's no difference between AR-15 and an M16. And like, what planet do you live on? And then the court, though, said the court that knew nothing about guns, that would, if it would say something like that, got rid of a vagueness challenge because everybody knows all the different parts and designs of guns. So they can ban a certain gun or a copy or duplicate. And if you want to get a totally different gun, you don't know anything about that first gun, you're supposed to know all the internal parts and everything that would make the second gun a copy or duplicate of the first gun. And I don't know about you. I mean, I like guns and gun parts and everything, but I don't think anybody in this room could do that. If you were a gun designer even, you would know about your gun's design, but you would not know what some other designer had in mind and how those parts are designed, just without even having access to the gun. Because remember, the gun's banned. It's an assault weapon. So how would you be able to make these comparisons? So what I'm looking forward to is the Fourth Circuit to deal with that Maryland law in light of the Bruen decision. And there were 2 magazine ban cases that were sent back for review in light of Bruen, and one was from New Jersey, and one was California. And then there was a no-brainer case that was sent back. If you remember, years ago, Hawaii had banned both open and concealed carry. So the Ninth Circuit held that, well, you can ban concealed carry, but we're not going to tell you whether you can also ban open carry. Then you have another case come up, and that circuit dutifully said, well, you can also ban open carry. So here we have the Supreme Court in Bruen saying that you have a right to carry per se, and that cannot be infringed. And the Ninth Circuit said you don't have a right to carry either openly or concealed. And I don't think there's much work to do there when that case goes back to the court below. So there you have it. I think we can look forward to some more precedents. The problem we have that we've had since Heller and then McDonald is the lower courts are in rebellion against Supreme Court cases. And why is that? So we're in Texas. There's no assault weapon ban. So there's no Fifth Circuit decision either invalidating or upholding the so-called assault weapon ban. Here's the problem, is that when you go to the Second Circuit, you've got New York, the New York state of mind, and you have judges on the courts of appeals who are from New York. They had to be approved by the senator from New York to get on that court, Chuck Schumer. And so they have that same anti-gun bias when they sit on these courts of appeals, and you have the most flimsy reasoning. You know, the New York State Rifle and Pistol Association versus New York, a prior case where the so-called assault weapon ban was challenged. The court didn't even bother to discuss the features that are banned. It just kept using the word assault weapon over and over and over, every other sentence virtually, and that's supposed to be persuasive. They never once try to explain what's so deadly about having a flash suppressor on the end of the rifle or some other feature. So as I recall, you wanted to interrogate me a little bit, and I should probably finish
Okay,
my part.
you
And
finish your part, and we're gonna do the interrogation at lunch.
okay,
So, yes, so we can get back on time. We're not on time because it's my fault, so go ahead.
no, I'm just gonna, um, I'll just conclude. Look, I look forward to the book that is going to come out, America's Rifle, The Case for the AR-15, is very comprehensive and going back to English history and the federal government basically has virtually played hands off other than the NFA for selective firearms, the assault weapon ban that only lasted 10 years. Basically, Congress has recognized it doesn't have power to ban guns, and it really hasn't done so. If you look at the history, we like to complain about new restrictions, but as far as bans, they've been pretty much off the table. They in '84, I think it was, they banned undetectable guns that did not exist, and a few things like that. But other than that, we have a long tradition in this country of recognition of the right, as much as some people in Congress and other political bodies don't like the right. We have the civilian marksmanship program. You can buy what General George Patton called the deadliest battle implement ever devised, an M1 Garand. You can buy one today. And so that comes from federal sources. So um, we really have a better deal than I think we realize, especially when you start comparing our laws with Europe and other countries that are even worse. So anyway, I look forward to being interrogated at lunch, and thank you very much. It's so good to see you, Julianne, and Alan again, and you all have a great day. Thank you.